Welcome back. You're watching The Firm. Forum shopping is a common occurrence in litigation. Lawyers will tell you that the Delhi High Court is the preferred court for all intellectual property cases. Often, even if the IP dispute arises in Mumbai or in Bangalore, the case is filed in the Delhi High Court. Now, the Supreme Court seems to have put an end to this. But has this recent judgment solved the problem, or has it made things worse for IP owners and their lawyers? Aayush Ailawadi finds out.
In 2007, Sanjay Dalia, a manager of Mumbai-based Cineline Cinemas, was accused of copyright infringement by the Indian Performing Rights Society. IPRS is headquartered in Mumbai, and the alleged infringement had taken place in Maharashtra. Yet the case was filed in Delhi, where IPRS had a branch office. IPRS could do this thanks to special provisions in the law. Under Section 20 of the Code of Civil Procedure, a suit must be filed where the cause of action arises or where the defendant resides or conducts business through a head office or branch office. But both the Copyright Act and the Trademarks Act override this Civil Procedure Code provision. They both provide an intellectual property owner with an additional forum, a district court in the city where the owner conducts business.
Section 134 of the Trademarks Act and also Section 62 of the Copyright Act gave certain special powers to the plaintiffs as against what existed under the CPC, that the plaintiff could go ahead and file a litigation in a place where it resides or carried on business. So CPC provided that you have to file a case in a city where the defendant is located or where the cause of action in full or partly arose. So this deviation was done by the legislature to help the plaintiffs and alleviate their problem of chasing infringers in different parts of the country.
But in both the IPRS case and in another similar case being heard by the Supreme Court, the defendants or alleged infringers of intellectual property argued that these sections were being misused by IP owners and the court must apply Hayden's mischief rule to such cases. Hayden's rule requires the courts to interpret contentious legal provisions in a way that the mischief is suppressed, the remedy is advanced, and the defendants are not harassed. So the Supreme Court held that the two sections must be interpreted according to this rule in a purposive manner.
The way this rule is applied is this: the court, while interpreting a provision, will look at the object or the mischief which the provision sought to overcome. And in this case, the object of the section was to ensure or facilitate a plaintiff in the sense that in the sense that a plaintiff would not be constrained to go all the way to where the defendant is located, or where the cause of action or the act of infringement has occurred, and instead would be in a position to sue an infringer in his own backyard, so to say. But in this case, as I said, in view of the peculiar facts of this case, where both the plaintiff and the defendant were located in Mumbai, and the cause of action had arisen in Mumbai, the Supreme Court felt that filing of a case before the Delhi High Court was really an abuse of the very objective for this, the very objective for which this particular section was enacted.
So the Supreme Court has held that if the cause of action arises at the place where a company ordinarily resides or has a principal place of business, then it has to file a suit at that very same place, which means that if the infringement takes place in Mumbai, where the company is based or where it has its main office, then it has to file a suit in Mumbai and not in some other city.
So now the Supreme Court in this particular case has gone into some detailed analysis of what has been happening in the country, and several cases where the plaintiffs had gone forum shopping and laid down some principles forever, saying that if a plaintiff carries on business in one city and the cause of action also arose in that city, the plaintiff should necessarily initiate the legal action in that city instead of dragging the defendant to another city of the plaintiff's choice or convenience.
Section 62(2) of the Copyright Act and 134(2) of the Trademarks Act have clearly been watered down or diluted. So, yeah, if there is a perception that these were provisions, long-arm provisions, jurisdictional provisions, which were capable of abuse or were abused in the past, I think that perception now will gradually die down.
In intellectual property cases, companies prefer to sue for infringement at the Bombay, Delhi, Madras or Calcutta High Courts so that they can bypass the district courts. For instance, in 2010, Microsoft sued a defendant in Delhi for an infringement which occurred in Bangalore. Although the company had a large business presence in Bangalore, had it sued in Bangalore, it would have to first approach the Bangalore City Civil Court. In Delhi, it could file a suit directly before the Delhi High Court. This can expedite the hearing and also means the case is heard by more experienced judges. Interestingly, of the four, Delhi is the most popular intellectual property litigation destination. More than 70% of all IPR infringement cases in India are heard by the Delhi High Court. In the present case of IPRS versus Sanjay Dalia, although the court hasn't explicitly addressed the rampant problem of forum shopping in intellectual property cases, it has said that the complainant's argument about there being superior intellectual property law expertise in Delhi is irrelevant when it comes to deciding territorial jurisdiction.
To answer your question as to why the Delhi High Court has often been seen to be the capital of IP litigation, so to say, is I think largely attributable to the late 1960s, when I think most IP litigators, that Delhi had the highest concentration of IP litigators even then, and I think it was the contribution of those men and women who I think really made the Delhi High Court a court that was very familiar with intellectual property principles. The Delhi High Court, I think, therefore had the opportunity to rule on a variety of intellectual property topics, particularly at a time when there were several legislative sort of gaps, and the Delhi High Court, I think, demonstrated tremendous proactiveness and openness and being willing to apply principles enunciated in foreign precedent and incorporating them under Indian law. And also there has, I think, been this perception that the Delhi High Court is more liberal in the grant of ad interim ex parte relief. I think that has been the case for some time. Other jurisdictions have been more conservative in the grant of ex parte relief, and especially when you're dealing with the problem of counterfeiting and piracy in a civil context. I think it is extremely important that ad interim ex parte injunctions are passed, court commissioners are appointed so as to catch the pirate or the infringer with smoking gun evidence. So the passing of orders without prior notice, ad interim orders, is critical. And because the Delhi High Court, granted these orders more frequently, I think the Delhi High Court became a favored sort of jurisdiction, so to say, for plaintiffs.
The Supreme Court decision may put a dent in the Delhi High Court's popularity, but the scope of the Supreme Court judgment may be limited. Lawyers argue that complainants could still pick preferred forums from among the chartered high courts of Bombay, Madras and Calcutta, which function under special rules.
These were high courts set up as Supreme Courts during the British rule, and now they are high courts, or they are chartered high courts, which have a letters patent jurisdiction, whereby, so for example, if in the context of, say, the Madras High Court, the Madras High Court, for example, could, in a deserving case, let's say it's an important question of copyright in the context of the film industry, it is perhaps arguably possible for a judge of the Madras High Court to assert jurisdiction over a civil proceeding whose cause of action has arisen in Kanyakumari, so that this question of law that the Madras High Court may rule on would then apply across the state. So it is possible under the relevant clauses of the letters patent to seek leave of the High Court and therefore assert the jurisdiction of the Madras High Court.
Supreme Court's approach is pretty clear, that the court wants the plaintiffs to follow certain discipline in initiating a legal action. And considering that the court did not clarify about how the latest patent filings should proceed hereafter, I think it will be ultimately for the Chartered High Courts to take a view on this, but my understanding is that this will apply to all the courts in case of IP litigation.
This judgment has certainly clarified the scope of the special rights of copyright and trademark owners in India, and while it may not be music to the ears of Delhi's IP lawyers, it will surely lead to the distribution of intellectual property litigation from Delhi to other parts of the country. In Mumbai, Aayush Ailawadi.
Well, with that, we're entirely out of time. Thanks very much for watching The Firm this week. We'll be back next week.
The Firm, India's only show on corporate law, tax and audit matters.